welcome to the session of Ethics in Engineering Practice. Today we will be discussing about workplace rights and responsibilities. In the earlier session, we have discussed about the professional rights and responsibilities of engineers. Today we will be looking into the workplace rights of the engineers and the workplace responsibilities of engineers. So, there will obviously be some overlap in these two discussions, as we understand, because engineering as a profession has its own responsibilities, which will also get repeated when we are talking of workplace rights and responsibilities. But along with that, there are other certain specific rights and responsibilities that the engineers have when they are working as a part of organization, and it is there that employer-employee relation with the organization, the internal stakeholder relation with the organization that generates its rights and responsibilities. And here in this session, we will be focusing on those rights and responsibilities. So, along with the professional rights, these will be some extra rights and responsibilities that we will be discussing in this particular session. So, let us look into the overview of today's session. The outline of the module will be, we will be discussing meaning of rights and responsibilities. We will be discussing about the duty of confidentiality, the criteria for deciding the confidential clause, what types of information should be kept confidential, changing jobs, confidentiality and management policies, justification for confidentiality, conflict of interest and sample situations for conflict of interest, and ethical corporate climate and its defining feature, and right of professional conscience, conscientious refusal, and employee rights. So, we have already discussed about importance of confidentiality. We have discussed about the conflict of interest issues in the professional rights and responsibility discussion also. Today, we will have a relook into these concepts from the workplace rights and responsibilities perspective. So, what we understand by right is, it is a legal entitlement to have or to do something. When we talk of responsibility, it is a duty or obligation to satisfactorily perform or complete a task assigned by someone or created by one's own promise or circumstances that one must fulfill, and which has a consequence of penalty for failure. So, if you are not meeting up your responsibility, you are not up to the mark for meeting up your responsibility, there is a consequence penalty for failure also. So, duty is an obligation to satisfactorily perform or complete a task, and when you are talking of right, it is a legal entitlement to have or to do something. At this juncture, we must understand, though right is a legal entitlement to have or to do something, it is practically not possible to enjoy any right if the corresponding other party who is connected to us is not carrying out his or her responsibility towards us in terms of like the duties that binds both of us together. So, if that duty is not performed, responsibility is not performed in one way, the other connected party can never enjoy the rights. So, rights and duties, rights and responsibilities goes hand in hand. We cannot just tell like we have rights for something until and unless we also realize that we have the responsibility of performing something according to the satisfactory standard, according to the level of expectations, and we have to keep our promises for it. So, that is why it is important to discuss about the responsibilities and duties at first. First, here we will be discussing about the duty of confidentiality. The duty of confidentiality is the duty to keep all information secret which is deemed desirable to kept under covers. So, one question may arise like who tells us to keep things secret? It is deemed desirable by whom? Who are the stakeholders? So, basically if it is any information that the client or the employer would like to have kept secret to compete effectively against business rivals. It could be any data concerning the company's business or technical processes that are not already public knowledge. So, it is generally that USP of the organization, that core competence knowledge or the skill which may give competitive advantage to the organization with respect to other competitors, that is what they want to keep secret. So, because they want to compete effectively against business rivals. So, now if we have discussed this, the natural question which may arise in our mind is then what are the criteria for defining what is to be kept confidential and what is not confidential? What is the seriousness of an information, seriousness of an issue which needs to be kept confidential? So, the criteria for defining the confidential clause are, actually there is no fixed criteria as such. It is what an employer considers to be confidential shall be kept confidential, because it is the employer's vision, employer's view, like this is important for me, and it is the employer's perception also. Next, it comes like if there is no fixed criteria for keeping things confidential. So, are there any special type of information which needs to be kept confidential? Let us have a look into it. Yes, there are types of information which needs to be kept confidential. We have already discussed this earlier. Let us review it again. It is the confidential data, it is results, information about upcoming unreleased products, information about designs or formula for products, business information concerning the number of employees working on a project, the identity of suppliers, marketing strategies, production costs and production yields. Engineers today are required to sign a non-disclosure agreement which binds them from sharing any information with outsiders. Government organizations like in defense sector have more stringent rules because of the security issues. Now, in the earlier discussion, while discussing about the confidentiality issues, we have discussed about confidentiality and when to keep, like not to tell it to the outside organization or outside society, and we have discussed the case of whistleblowing over there. Like if the employer is doing something wrong and the employer wants that to be kept secret, as an engineer, as a professional, should we keep secret, or it is a professional ethics which tells no, we are primarily duty bound towards the society's protection at large, the welfare of the public at large, and we should go and try to whistleblow. We should try to generate the awareness of the wrongdoings first to the inside of the organization, to the higher ups, and if they are correcting themselves, it is fine. We should try to make them understand so that they correct their wrong processes and do something in the right way. But if things are going beyond control and they are not listening, then maybe we can go to the outside world or the board of directors and then to the outside world and find out a solution. When there is again a conflict of interest between like what the employees are telling to keep secret and what is good in the interest of the public at large. Here we will discuss about confidentiality and the changing of jobs. For engineers, it is very frequent, like they are changing jobs, organizations very often, and how does then this confidentiality be maintained, or till what time it should be maintained, and how does it affect the changing of job, or is it related to the changing of jobs or not. Let us review those with respect to confidentiality, the changing of jobs, because here we are discussing about the workplace rights and responsibilities. So, the responsibility to protect the information actually does not end when an employee leaves the job. If it was the case, then there would have been no way to protect the information. Previous employees would quickly give it away to their new employers, or perhaps for a price sell it to competitors of their former employers. Thus, the relationship of trust is actually very important over here between the employer and employee in regard to confidentiality. It continues beyond the formal period of employment. It is ideally supposed to continue beyond the formal period of employment. Unless the employer gives a consent, former employees are barred indefinitely from revealing trade secrets. This provides a clear illustration of the way in which the professional integrity of engineers involves much more than their present loyalty to one's own, more than loyalty to their own present employer. So, this is the professional integrity of the engineers actually, which restricts them from telling any secret of the past employer to the new new employer. So, this is where, like when you are talking of why professional ethics is important for an engineer, due to this reason, because the employer may not directly stop you, may not be able to stop you, may not be able to monitor you to find like whether you have actually shared the information with their competitors or not. But it is your personal integrity, the character, the professional integrity of the engineer, which restricts the engineer from telling any secret of the past employer to the new employer. So, these type of things is where the professional ethics becomes important, really important, and overrides in the decision making when a person is in point of dilemma, like whether to share the secrets or not to share the secrets, because the new employer may be giving you gifts, may be giving you bribes to understand the trade secret of the past employer. In this case, what you are supposed to do, it is your professional integrity as an engineer will give you the guidance of what exactly you need to do in this regard. So, we will discuss here about a high profile case of trade secret violation. A high profile case of trade secret violation was settled in January 1997 without coming to trial when Volkswagen agreed to pay General Motors Corporation and its German subsidiary Adam Opel $100 million in cash and to buy $1 billion in parts from GM over the next 7 years. Why this happened? Because in March 1993, Jose Ignacio Lopez, GM's highly effective manufacturing expert, left GM to join Volkswagen, a fierce competitor in Europe, and took with him not only 3 colleagues and know-how, but also copies of confidential GM documents. So, actually Volkswagen is trying to compensate for the loss that GM had in its intellectual property. So, to restrict this, so you cannot ensure like these are not going to repeat again. You cannot monitor also people from once they have left and gone outside. So, as a company, are there anything that can be done so that it acts as an incentive, it acts as an incentive, or it restricts people from, it restricts engineers from doing this? Can there be any management policy regarding these confidentiality issues? Can we do something regarding it in terms of incentives or reinforcements or policies? Let us look into it. Confidentiality and management policies. Here we discuss about one of the approaches where the employment contract that place special restrictions on future employment, like restrictions related to the geographical location of future employers, the length of time after leaving the present employer before one can engage in certain kinds of work, and the type of work it is permissible to do for future employers. But the issue is in such contracts threaten the right of individuals to pursue their careers freely. So, you can understand when you are talking of conflicts of interest. So, here it is like if you are imposing so many like restrictions, it is somewhere threatening the right, the legal entitlement of the individuals to pursue their careers freely. So, thus these are not recognized as binding by the court. So, you cannot force the people for doing it. Another approach is to, so that was a restrictive negative approach. Another approach could be a positive approach, which it is to offer certain benefits like portable plans, say pension plans to engineers for not working with competitors on certain kinds of projects after leaving the company, or could relate to offering special post employment annual consulting fees on the condition that he or she should not be working for a direct competitor during that period. The best way is to generate again a sense of professional responsibility among their staff that reaches beyond merely obeying the directives of current employers. So, this again this part is very important discussion. So, organization can try many ways out, either by threatening you or by trying to incentivize you in terms of restricting you from the engineers from not sharing secrets of the present employer to the future employers. But all these measures may or may not yield the result. You may try to threaten me, I may not get threatened, I will join a new organization, take money from there and pay you back. You tell me you will be given me pension plans, you will give me consultancy fees, but I do not see these to be like much worthy in terms of money, because the new company that will go and join will be paying me much higher, and they will be paying me higher because I share your secrets with you. So, by doing these processes, the management cannot really ensure like these are going to give 100% result, until and unless it is a call from within the person, it is a call from within the conscience of the person, of the engineers, in terms of professional responsibility, professional conscience, like I should not be doing sharing the information of my past employer with the future employers, and I should maintain my integrity in that way. So, the best way to generate is to ensure like the secrets will be maintained, is to generate a sense of professional responsibility in the engineers, because giving threats or incentives or directives to follow the instructions of the current employers may not always yield the proper result. So, what are the justification for confidentiality is? The primary justification is to respect the autonomy, freedom, self-determination of individuals and corporations, and to recognize their legitimate control over some private information concerning themselves. And all the major ethical theories recognize the importance of autonomy, where it is understood in terms of right to autonomy, duties to respect autonomy, and the utility of protecting autonomy or the virtue for respect to others. So, we have to respect people's autonomy, we have to respect the private space of the person, where the person may or may not be willing to share certain parts of the secrets with the public at large, and we need to respect that part of autonomy, and we have to, it is our responsibility also to protect the autonomy by the virtue of respect to others. That is why confidentiality is important. So, another importance of confidentiality is the trustworthiness part. So, when the clients go to attorneys or tax consultants or even doctors, they expect them to maintain confidentiality, and the professional ethics indicate that confidentiality will be maintained. Similarly, employees often make promises in the form of signing contracts not to divulge certain information considering sensitive by the employer. Revealing their information would surely account for the breach of trust. Here again I like to highlight, like this also we need to understand then again if the importance of these information, like if it is something which is damaging to the health, welfare and safety of the public at large, then of course the right of the person, the conscience of the engineer as a professional responsibility of the engineer to protect the right health, welfare and safety of the public at the large is the overriding principle, caring principle, which will tell like it is a primary responsibility or primary responsible to the public at large. And even if you have signed a confidentiality document, a bond where there is certain sensitive information which is not to be shared, but if that sensitive information is such which is acting against the interest of the public at large or the safety welfare of the public at large, then it is a part of the responsibility of the engineer to sound a voice regarding it to the higher ups or to the boards or to the society at large, and that is where whistleblowing of course comes in. So, there are public benefits in recognizing confidentiality relationships as well as professional contracts. So, if suppose in case of doctors, like if confidentiality is not maintained, then maybe the patients are not going to come because it requires doctors knowing some private information about the patients which they may not want to discuss with the public at large. For engineers, we have to be careful, like we serve at the best interest of the public at large, and when to voice, about what information to voice needs to be a very rational and logical decision for the engineers to take. Next, we will discuss about conflict of interest. Professional conflicts of interest are situations where professionals have an interest that, if pursued, might keep them from meeting their obligations to their employers or clients. So, we have already discussed this over, like when you are talking of competitive bidding and why engineers are not permitted to enter into competitive bidding, and if you are a decision maker in terms of selection of suppliers and you also have a company who supplies same types of goods, then whether you will be able to do it or not. So, these conflicts of interest we have already discussed earlier. So, why it is a concern? What is the concern in conflict of interest is it is largely centers on the potential to distort good judgment in faithfully serving an employer or client. Exercising good judgment means arriving at beliefs on the basis of expertise and experience as opposed to merely following simple rules. So, there could be conflict of interest and conflicting interest. So, conflicting interest means a person has two or more desires that cannot all be satisfied given circumstances, but there is no suggestion that it is morally wrong or problematic to pursuing them. But in professional conflicts of interest, it is physically or economically possible to pursue all the conflicting interest, but doing so will be morally problematic. So, what could be the sample situations for conflict of interest, like gifts, bribes and kickbacks, interest in other companies, insider information. So, we have already discussed about insider information. So, what are gifts, bribes and kickbacks? A bribe is a substantial amount of money or good offered beyond a stated business contract with the aim of winning an advantage in gaining or keeping the contract, and where the advantage is illegal or otherwise unethical. Bribes are illegal or immoral because they are substantial enough to threaten the fairness in the competitive situations. Gifts are not bribes as long as they are moral gratuities offered in normal conduct of business, but often this thread, there is a very narrow line over here, and sometimes gifts are become so like costly that it becomes bribes in disguise. So, you have to be very careful when gifts are gifts and actually when gifts are bribes, because in bribes there is an expectation to do something or winning an advantage for something where the advantage is either illegal or unethical. And second, we will be discussing about interest in other companies. Some conflict of interest consists in having an interest in a competitor's or a subcontractor's business. It could occur if an employee is actually working for the competitor or subcontractor as an employee or consultant. Another example is a partial ownership or substantial stock holdings in the competitor's business. So, in that case there could be possibility of like passing away secret of one organization to the other organization. Sharing insider information, it is a specially sensitive conflict of interest which consists in using inside information to gain an advantage or set up a business opportunity for oneself, one's family or one's friends. The information might concern one's company or another company with which one does business. For example, engineers may tell their friends about the impending announcement of a revolutionary invention which they have been perfecting for their corporation's plan, or for the corporation's plan for a merger that will greatly improve other companies' stock. So, being an inside of the organization, if you are sharing certain information to set up a business advantage for yourself, your own family or own friends, then this is called to be insider information, and that is also unethical, because here we have to understand keeping the confidentiality of the information for the employer is one of the primary duties of the engineers or the employees of the organization. We will discuss about the moral status of the conflict of interest. So, it is a question for you to ponder on, like, do you think like conflicts of interest are always unavoidable, or is it morally incorrect to pursue conflicting interest as an employee? What do you think? Or is there any way so that we can balance these? If you remember, in the last class we have discussed while we discussed this in the professional ethics responsibilities. So, it is actually not always like unethical to pursue conflict of interest conflicts, but in practice, like, some conflicts are thought to be unavoidable or even it is acceptable. Like, one illustration is that the government allows employees of aircraft manufacturers such as Boeing or McDonnell Douglas to serve as government inspectors for the Federal Aviation Agency. The FAA is charged with regulating airplane manufacturers and making objective safety and quality inspections of the airplanes they build. Naturally, the dual roles, government inspector and employee of the manufacturer being inspected, could bias judgment. Yet, with careful screening of inspectors, the likelihood of such bias is said to be outweighed by the practical necessities of airplane inspection. So, from situation to situation basis, case to case basis, we can have like ways of solving these conflicts of interest. So, we will discuss a small case over here, and like Kane is a process engineer for Stardust Chemical Corporation, and he has signed a secrecy agreement with the firm that prohibits his divulging information that the company considers proprietary. Stardust has developed an adaptation of a standard piece of equipment that makes it highly efficient for cooling a viscous plastic slurry. Stardust decides not to patent the idea, but to keep it as a trade secret. Eventually, Ken leaves Stardust and goes to work for a candy processing company that is not in any way in competition. He soon realizes that a modification similar to Stardust's trade secret could be applied to a different machine used for cooling fudge, and at once has the change made. So, this again brings us to the area where, like, again it's a point of like dilemma, where it's point of debate to understand, has Kane acted in unethical way and who is the owner of that knowledge, because they have not, Stardust decides not to patent the idea, but to keep it as a trade secret. And again, Kane as a process engineer, he has signed a secrecy agreement with the firm that prohibits his divulging information. So, that company considers it's proprietary. So, in solving this type of dilemma, we have to understand, so like whether like it is possible to in this case, in this case we have to think like what are the possible points, like to what extent Kane have used this. Before we come to conclusion about this, has he used the knowledge as it is, like then who is the owner of the knowledge, because they have not signed any patent idea, they have not signed the patent, then who is the owner of the idea, and then to what extent the design, the idea that Ken has shared to and applied to a different machine used for cooling fudge. So, what is the degree of similarity and transfer that has been done over here, and whether this has given any threat to the existing company's competitive advantage. So, this decision about this is it needs to be looked into like from different moral perspectives, also from the utilitarian perspective. You need to look at it from the rights and justice duties perspective, you have to look at it from the justice perspective also, and the care perspective. But the case needs to be like delved into much deeper in the sense, like in terms of then if this is a like a chemical corporation and this is a candy processing company, how much similar they are to each other, are they competitors of each other, maybe not now, can they be so in future. So, and for this, what is the importance of this, what is the importance of this design, so standard adaptation that they have done of a standard, how much it is important for the business of this organization, and what degree of adaptation have they made as a standard piece of equipment, and how much that knowledge is transferred over here, and is it done to a similar kind of machine, or it has been done to a different kind of machine. Here what we see is it is done to a different kind of machine which is used for cooling fudge, and here it is for cooling viscous plastic slurry. So, what is the degree of similarity and dissimilarity between these two functions? Can in future they be acting as competitive to each other? We have to look into these future things. Then what we understand, like who designed this, like was Ken the person who designed this adaptation? The case here does not tell us anything about it. So, whether who was the person whose idea was involved over in this adaptation of the standard piece of equipment, was it Ken himself or it was somebody else, and Ken has observed that and he has used it over here. So, this word patenting your idea, we are talking of it as a proprietary thing, but we have not patented the idea. So, there are some like gaps over here, but above all, like if you talk of like who owns the knowledge, we will tell it is the like the company maybe owns the knowledge, because from here we do not know also like to what Ken contributed in designing this thing, and to what extent has been the transfer over here, and whether Ken has acted unethically. Yes, of course, to certain extent there is it has been unethical, because without the knowledge of Stardust after leaving, maybe he has applied it to a different machine altogether, but somewhere it has been replicated without the knowledge of the this previous employer, and it is the violation of the secrecy agreement that prohibits his divulging of information. So, in that case maybe we can consider he has acted in an unethical way, the degree can be debated, like to what extent it was unethical and all. In the next, we will discuss other cases about like whether the actions of client A is morally permissible or not. In these lectures, we will be discussing few cases which will help us to understand the moral situations and dilemma, and how we can understand what are the rights and responsibilities of the engineers with respect to it. Thank you.